Hi, everyone. My name is Rachel Marks, and I'm the Director of Education here at SunRay. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. SunRay secures over $10 billion annually. Today's webinar is conducted by the incredible Leslie Bowe, a Missouri and Kansas construction lien law guru. Today's webinar's topic is, what happens after I record my lien? How do I get paid? So without further ado, I'd like to introduce the fabulous Leslie Bowe.
Thank you, Rachel. I'm pleased to be here today. I appreciate your introduction. I am really excited about this topic. This is one of the most commonly asked questions from my clients is, how do I get paid? At what point, we've done all this work, how am I going to get paid now? And the great news is, oftentimes, even just filing the lien will get my clients paid. It's such a powerful tool in our toolbox, and I like that for my clients. It's so beneficial, and a lot of times this may be the end of the road. However, unfortunately, sometimes there are situations where we do have to take it a little further, and just the filing of the lien doesn't get the client paid, and so that's what we're going to talk about today. I know that we've got a little housekeeping here, so there is a chat box on the right. If you have any questions that come up while I'm talking, please enter those there and we'll go through them at the end. No question is a dumb question. Please feel free to go ahead and put in your questions there. And then obviously you can see the instructions here, but don't include your company names or your names in the questions. We'll just do those anonymously. And with that, I think we can jump right in. So as I mentioned, our mechanics liens are a very powerful tool to get paid. If you haven't been through the mechanics lien process yet, one of the big, one of the big issues that it creates for those involved in the project is that it is an encumbrance on the real property, so it will immediately involve the owner. And the owner's not going to be happy, and they're going to start putting pressure on the general to get you paid if you're a sub. If you're a general contractor, they're probably already aware of the fact they're not paying you, and there may be some disputes around that, but the mechanics lien going on the property is going to raise flags across the board in terms of their higher ups. So lenders on the project, the mortgage holder on the project. Oftentimes the mechanics lien is going to be a breach of the owner's obligations under their promissory note, or if you're doing tenant finish work for the leasehold owner with the actual owner. So this is going to create a situation that gets people's attention. And there will be pressure to get the lien released, and that's going to give you a very powerful negotiation tool. I have had people who will stick to their guns and get paid in full, but if you guys, the clients, need to make business decisions, and sometimes it's better to get some money in the hand and move on and do what you all do best and go make more money somewhere else and put this behind you. So even if you are willing to take less and just settle the claim, it's still a good idea to have your lien on file, because you will have a more powerful negotiating stance. And this is because ultimately the end result of what we're going to talk about here today after the lawsuit proceeds is that you can sell the property to satisfy the lien, and nobody wants that to happen. So we have situations where, and you guys probably know this, the pressure to make a payment comes, everybody feels that pressure at different points. You send an invoice and you get paid. Some people need a demand letter. Some people, you have to get lawyers involved. Some people filing the lien will get their attention and get you paid. But there are those out there, whether it's just circumstances or their nature, they're not going to pay until they really have to. And so at the end of the day, before the property gets sold on the courthouse steps, the chances are you're going to get paid. So with that, we will move on. So the mechanics lien process is sort of a three-phase process. We talk about it in the legal realm as attachment, perfection, and enforcement. One of the great things about mechanics liens is that your attachment, in other words, the date of your priority with all the other encumbrances on the property, will be from the first day of work. In Kansas, it is the first day of any unpaid lien claimant's work. So you will all relate back to the earliest unpaid lien claimant. What that also means is that a bank or owner could pay off an early filing lien claimant to gain priority. So that's an extra issue we have in Kansas that we don't always have in other states. So let's say from the very beginning of the project, there's some problems, and you've got the whoever's doing the site work and the underground utilities still isn't paid. They're one of the earliest contractors out there, and that's going to give everybody pretty good dates for priority. But a lender could, if their mortgage wasn't recorded until after that work started, pay off that earliest lien claimant and gain priority. So that's just something we have to factor in to our strategy of how we're going to proceed in Kansas that we don't always have to in other states. Perfection is the filing of the lien, and enforcement is when we file suit to go ahead and foreclose on the lien. So because today we're going to talk about what happens after you file your lien, we are going to assume that the lien has been perfected. So you are a proper lien claimant, and the lien claim is for lienable items. In Kansas, this means that if you're a subcontractor, you've contracted with or a supplier really, you have contracted with the subcontractor, contractor, or owner contractor. This is important because in Kansas, lien rights don't go on forever. So if you're a supplier to a supplier, we could be in trouble in terms of gaining lien rights. So it's a conversation you'll want to have with whoever's filing your lien right early on to know where you are in the contractual chain to be sure you are a proper lien claimant. The other thing we're going to assume is that all your notices were properly given, both served properly and done timely. There's different forms of notices that have to be given for different kinds of liens in Kansas. In Kansas, we've got some special notices for residential property. Again, we're not going to go into all those details today because our focus is on how you get paid after you file the lien, but we will assume those were all done. And then we will also assume that your lien was properly filed, that it includes everything that it has to have in it. It was timely filed. In Kansas, that means as a subcontractor, you filed it within 3 months of your last day worked. A general contractor is 4 months. However, on commercial projects in Kansas, you can extend the time of filing a lien to 5 months as long as you filed a special notice of extension within your original deadline. So you do still have to be mindful of the 3 and 4 month deadlines. And I've got a little clock here just to remind us that these are all very time sensitive. You're 1 day late, you will lose your lien rights. Also noting here, in Kansas, your lien has to be perfect and follow all the statutory requirements, because in Kansas, we've got some case law on the fact that you can't amend a lien to cure a defective lien. So while you may be able to amend a lien for some purposes, you cannot cure it a defective lien by amendment, because technically you didn't have a lien, so there's nothing to cure. So you want to make sure those things are all right when you file them. Enforcement process begins with filing the lawsuit to enforce and foreclose on the lien. In Kansas, we have a whole year to file suit to enforce. This is longer than a lot of other states. My neighboring state that I work in quite a bit, in Missouri, it's only 6 months. Both of these are kind of a lot of time in the life of a construction project. If you haven't been paid honestly within a month or so of the lien filing, typically we recommend to go ahead and file suit to enforce. The good thing is having the time does give you time to negotiate without having to incur the expenses of filing a lawsuit. So in situations where, let's say you aren't getting paid, but there's not a real dispute about your work, but somebody higher up in the chain is fighting about whether or not they should be getting paid for the scope, or whether maybe there was some defective work, you do have a little bit more time to wait out the resolution of their dispute before you have to file suit. But if you don't file suit within 1 year of the lien filing, your lien is no longer effective. So that is a deadline we can't ignore. And I would always encourage everyone to get in touch with their attorneys long before that 1 year, because you don't want to be filing on the last day. You just don't want to take any risks that there's any problem with the filing system or anything like that. So even if you want to give your customer time to try to get you paid without filing suit, don't wait the full year before you contact the lawyer. The parties to the lawsuit is one of the issues that will, again, get a lot of people's attention. So you're going to name in the lawsuit anybody whose interests will be impacted by your claim. And all the lien claimants will be named, any mortgages or other encumbrances on the property that are secondary to yours. Technically in Kansas, we do not have to include a prior mortgage, but we always do. We want everybody who has a stake in this property to be involved and have the opportunity to litigate the validity and priority of these liens. Obviously, we're always trying to get priority, so we would name them and work out who technically has, let this court decide who has priority. And I keep mentioning priority. If that's not clear why that's important, when the property is sold at the end of the day, after all the litigation and the liens have been proven up, the order that people get paid out of the proceeds of the sale will depend on the priority. So this, you can imagine, this might be an issue if there's a large mortgage on the property and we aren't sure how much the property is going to sell for. You would like to be high up in that priority chain so that your claim gets paid first. Amendment. Okay, so I think I've already mentioned this a little bit. So we can, even after the lawsuit has been filed, we can amend the lien. The statute actually says you can only do it to increase the amount claimed. Case law tells us that there's a lot of reasons people have attempted to amend their liens. And again, the case law tells us you can amend your lien, but not to cure a defective lien. So for example, if you name the wrong contractor, or you actually in Kansas, if you just misstate the contractor's name as and with a little issue as Inc. instead of company, or LLC instead of Inc., that can kill your lien. So you want to make sure those liens are perfect. I did want to mention that there are some alternatives to the traditional lien foreclosure suit to get you paid. So in Kansas, we have a statute that allows an owner or a contractor to bond around the liens. And this can be done without the lien claimant's permission. So you may file a lien and then you get a notice in the mail that somebody's filed a bond. This is not, a lot of people see this as a good thing. What it does, though, is remove the pressure of the owner or lenders being concerned about your lien. So while on one hand, you will have money that you know is there, you no longer have to worry about if the property is going to sell for the right amount or if you have priority, but you are going to lose some of the interested parties who might have been putting pressure on the parties to get paid. There's also an option to assign for an assignment of a lien claim. So we see this where maybe a general contractor, let's say there's 2 or 3 subs or suppliers that have filed liens. Maybe the general contractor is going to negotiate some sort of settlement with those lien claimants, take assignment of the lien claim, and then go ahead and prosecute the lien claim in their name as the assignee of the lien claim. And that's something that we see happen. Obviously, whether or not that's good or bad for you really depends on your situation. So, and the negotiating that you do with the person who's taking the assignment. So thinking outside the box, sometimes what we see is if you have a really large lien claim that they can't pay in full, we'll negotiate an upfront payment, a substantial upfront payment with a percentage payment based on what they ultimately collect after enforcing the lien. So situations like that might get you paid quicker and get you out of the full lien enforcement action. So your lien enforcement action is really going to proceed like any litigation. There's a lawsuit filed, all the defendants are named, they're all going to hire lawyers, file answers, there will be a discovery process where there will be documents exchanged. Depending on the issues, I've had cases that where the problem with payment is because maybe a lender or an investor has disappeared and no longer financing the project. Or maybe there's a problem with getting payment from the owner because of some defective work on the project. but it's really isolated to just 2 or 3 contractors or one issue, you may be able to skate through the lien litigation, just sort of riding the coattails of everybody else if there's no issues with your work, or if you're a supplier with the material that you furnished. In which case, while lien litigation can take some time, it may not be that costly. However, if you're one of the reasons that payment isn't being made, the discovery process might stretch out and create the situation where the litigation might be a little more costly, because there will be document exchanges. And as I'm sure everybody on the call or listening later will not be surprised to hear, on a construction project, they can be very high volume document cases. So when we do document exchanges, the documents coming from the general contractor, some of those large subcontractors, can be very extensive. And then there's depositions exploring all of the disputed issues with regard to the claims. If you are one of the parties who there's no dispute with regard to your work, there may be issues with priority, in which case there's going to be some discovery with regard to the lender and when mortgages were recorded, when work was actually started, because we do have, like I mentioned earlier with the attachment, the priority of the lien claimants is going to date back to the first day of work on the project by the earliest unpaid lien claimant. So there may be discovery of that issue as well. At the end of the day, the ideal situation is that the lien claimant comes out after, if you have a trial, on these issues, you'll have a trial, but a lot of times we may work out a lot of these legal issues through summary judgment or even stipulations. But at the end of the day, what you're going to come out of the litigation with is a judgment from the court saying the lien was properly perfected, you've got a valid legal interest in the real property, and that the property may be sold to satisfy your lien. At that point, so if you've gotten all the way this far without anybody coming to you saying what's going to take to make this go away and let's get you paid, this is definitely a time when that happens. So I've had cases settle, hours before the sale starts, because ultimately, if there's any value to the property, generally there's enough people interested in making sure that the property isn't sold to the lowest bidder on the courthouse steps. I've actually had cases settle while I'm driving down to some rural county for a sale. So I always tell clients, this is such a powerful tool to get you paid, that even if we do have to go through this whole process, you're much better off having your lien to enforce than not, because otherwise you've just got a judgment and an entity to go after, and you're hoping where their bank accounts are, or where they've got work that you can go garnish, the proceeds of their projects. With the property there, it's just such a powerful tool to get you paid. It's invaluable. What will happen is you'll get a writ of execution and the sheriff will sell the property. And one question that comes up is if the proceeds of the sale are not sufficient to pay everybody in full, the lien claimants, because we're all going to be utilizing the same data priority, will be paid pro rata on their claims. So everybody's sort of in the same boat, lien claimant wise. In some states, the first filed gets paid first and that kind of thing. But there's no race to the courthouse in Kansas like we see in other states, because all the lien claimants will be paid pro rata. Just to be aware, some things, these are probably the most common issues I see as lien killers, and these are defects in the mechanic's lien statement. So because what we are doing is enforcing a statutory right, this is not something that is sort of an equitable common sense, this isn't fair, we're going to pay this person. This is a right to get paid that's created by statute, and you have to follow the statute to a T in order to have a good mechanic's lien claim. Whilst contractors always feel like, hey, this isn't fair, we should get paid. What we're doing is we're enforcing the duty to pay on somebody who didn't hire you, and maybe the person who didn't screw up and misuse their money and not have the money to pay you. So in order to force an owner or a lender or anybody else who doesn't want to see this property get sold at a sale to come up with money and pay you, perhaps paying twice, because we don't know the situation. A lot of times We've got situations where an entity's gone out of business and they took the money and ran, or they took the money and spent it on something else. So if an owner or general or even a subcontractor has to come up with enough money to pay somebody twice, that's the kind of situation where you have to have followed every statutory requirement to a T in order to have a good claim to enforce. The other issue I've mentioned a few times is priority problems. So if there are superior liens on the property, then there may be concerns about what the property is worth and whether a sale will generate enough money to pay everyone. And these are all just things you're going to have to factor into all your analysis of how to proceed all the way through. So remember, I mentioned there were some options to alternatives, whether you're going to take an assignment and get some money up front and let somebody else go pursue that lien claim, or whether somebody's filed a bond and now you're fine with that because there is a surety who will ultimately pay whoever proves up their bond or their lien claims. Those eliminate priority problems. So it's just factors to consider as with your lawyer as you're deciding how to proceed. Another big one we see is lien waivers. Some people will sign lien waivers without even looking at them to get that, progress payment. So we want to make sure you read the lien waivers, that they're not too broad, that they are appropriately limited in either time or amount. So if you're signing a lien waiver that says you've been paid in full for everything up until, January 1st, but you're signing it on, so September 15th to get your progress payment and whatnot, you don't know that you're not going to be asked to do some work that you haven't been paid for. So we only want people signing lien waivers they've read carefully and that are appropriately limited in scope. And then also one issue that can come up is payment bonds. So obviously payment bonds are very good tools to get you paid. If you're on public property, you can't file a lien. So because both bond claims and lien claims are very time sensitive, we want everybody to do a good analysis when they realize they're not getting paid and they're deciding how to proceed at that time as to what type of property this is, whether or not you have lien claims, whether or not you have bond claims. This gets murky when we're dealing with property that's perhaps publicly owned and leased for private use, or it's private use but publicly funded. So these things can be murky. It's not always very black and white, and it's an analysis that needs to be done early on, because you hate to get too far down the line and doing your mechanics lien work and perfecting your lien and enforcing your lien, and then find out, oh, I don't even have lien rights on this project, and now I'm out of time to make a bond claim. So these are all factors we encourage everybody to pay close attention to so that we don't run into problems in the litigation process with somebody attacking your lien. And that's all I've got prepared. So at this point, I'm wondering if we've got some questions that have been submitted. Rachel?
Okay, first of all, thank you so much, Leslie, for your time today and educating us on this important topic. You provided us with super helpful and extremely valuable information on this webinar, so thank you.
Of course.
Let's see if we have any questions. I don't see any that have come through just yet. However, if anyone that is watching, if you do think of a question after the webinar, just feel free to reach out to myself or Leslie, and we will make sure to answer any question you may have. If you'll just go to the next screen for me, Leslie. Okay, if you guys would like to take a moment to review us on Google, that'd be great. And if you'd go to the next screen for me, please. Okay, so I wanted to go over our upcoming webinars with Leslie. So the next one will be on Wednesday, July 26th, and the topic is don't sign a waiver or release without reading. And then the next one will be on Wednesday, October 25th. And the title of that webinar will be Getting Paid Faster with Liens, Bonds, and Contracts. So feel free to register at sunraynotice.com/education. And if you go to the next page for me, and that's it. So thank you everyone for your time, and I hope everyone has a sunny day. Thanks so much.
Thanks, Rachel.